Okay.
Alex here, Administrator of our Nevada Judges, with Amber Stevenson, Administrator of Nevada Pandemic Unemployment Facebook group. So, even though I can't answer questions specifically regarding the case, I can answer questions that people might have that are generally about the court system. If you or any of the people in the comments do ask questions that I can't answer, what I'll try and do is convert them into a way that I can answer them, and I'm going to try and give the most detailed answer that I possibly can within the limits of my role. So go ahead, I guess, and introduce yourself because this time this is not an unlisted live feed. This is a feed that will be viewable even by people who are not in your Facebook group. Go
hmm
ahead.
So my name is Amber Stevenson Hansen, and I am the administrator for the PUA group in Nevada, which stands for Pandemic Unemployment Assistance of Nevada. We have been up and running since the stand up of PUA in the state of Nevada. And we have been providing now over, I think we're close to 16,000 now, claimants with support and a space to understand their claims and the process of that claim, and to basically feel supported and heard in whatever they have going on with their claim.
So just so you guys know, if you can't hear me, let me know because I can increase or decrease sound. Go ahead, Amber, and just say test 1, 2, 3, just so I make sure I got you.
Test one, two,
Okay,
three.
so I have audio from both. I'll watch the comments just in case any of your viewers can't hear one or the other of us, and then I'll adjust the sound accordingly if I have to. I guess I'm gonna try and you guys are gonna see me looking to the side a lot. That's because I'm looking at the comments, and I have to look at both the Facebook and the YouTube comments at the same time. So don't mind me if you see me looking to the side a lot. Go ahead and ask me your first question, Amber. Until I see a question in the comments that I can answer, I'll just go ahead and let you control this. So just go ahead, ask whatever you want.
Right. So I think a lot of us are just really confused by this outcome today. It was obviously, we didn't go in with heavy expectations, but, you know, um, we definitely know that people don't have 2 more weeks. I know this of my collective because I've come to know them well. They're our family. They are not strangers. They're people that we have learned to love and adore and admire. And there's a great concern of, again, now waiting another 2 weeks.
Mm-hmm. First thing, some people couldn't hear me, so I went ahead and increased my sound. Hopefully, that's better for you guys. Let me know if you still can't hear me. The delays, I guess, is what I can explain. Again, guys, I can't answer as to the specifics of your case, but I can say that generally I do see a lot of continuances in pretty much every case. So this isn't really something that is just. What I guess I'm trying to say is it doesn't look to me like you guys are being picked on because of all of the cases that I've covered. It is pretty standard to see continuances and multiple hearings and stuff like that. I also try to answer this question in sort of an analogy or a comparison, I guess. I feel like to the average person, oh, like one day is almost comparable to what a week is to the court system, and then 1 week to the average person is like a month to the court system. So to them, it doesn't seem like that long. Whereas
hmm
to you guys, it seems like a very long time, but to the court, it seems like a comparably less amount of time. And it's probably just because the industry itself has gotten very used to these types of delays. So go ahead and go into your next question. I'm going to keep turning my mic up. Go ahead.
So now we're kind of just left here in this like next step place and knowing what we have done, which maybe people aren't familiar with the things that we've done in the framework of our group, is we have sent quite a bit of documentation to GASO and to Mark's office, primarily over the last couple of weeks. And um, there were a lot of things that were not issued. We had sent many subgroups, obviously, of the breakdown of the issues that D.E.T.R is experiencing on the PUA side and some on the UI side, and just as a whole. Um, the best outcome would have been to call in the National Guard at this point. So to again be put back into this queue of let's send emails again when we've already spent a week and a half doing that for 2 more weeks. Um, what type of volume are we talking about them needing to see? Because we feel like we've sent thousands. There's been thousands of emails that have been sent to both people, and we felt like that was sufficient enough. And it just seems like there's like a pretty gross negligence at this point.
So first thing, I'm still watching the comments. I went ahead and switched audio feeds. Hopefully that's better for you guys. Keep posting in the comments if you can't hear me as well as you'd like. The answer to your question there is, so I guess the way that I like to answer this question, because I hear this question a lot, is there's, in my opinion, three different types of solutions. One is legal, one is political, and one is through the media. And when it comes to what you're talking about, which is sending hundreds or thousands of messages, you're talking about the sort of media solution. And in
Mm-hmm.
my opinion, for a media solution to really gain traction, they're expecting like hundreds of thousands or millions of communications. So to you guys, it
Mm-hmm.
might seem like 100 or 1,000 is a lot, but to them, it doesn't really. To them, it's just they're used to seeing a different amount of volume. So again, there's that disconnect from what I think the average person thinks versus what the media thinks. And then of course what's going on in court is the legal approach, the legal solution. So you guys have two different approaches that you're taking to solve your problem. One of them is media, one of them is legal. And since you asked me a question specifically about the emails that you were sending and the volume, I'm not going to go into the other question, but if you have another question later on what's going on legally, I'll try and answer that to the best of my ability. So keep going.
Yeah, and so like obviously since we're using this media platform, I want to clarify for people that are new or obviously you're going to see this outside of our group. Our group is designed in a framework similar to the UI group in Nevada, which we use topic sections every day, and we've kind of used this for the last couple months to cumulatively collect data from our collective, and we found it to be very successful. And we thought that we had done our due diligence this last week because myself and our team and the collective rose to the occasion. I mean, there were daily phone calls with Mark's office. There were obviously some issues with getting emails to Gasso because he's out of the office until the 10th. But it just seems like the judge is ruling today and saying to people, we have 2 more weeks, which is to me unacceptable for the collective of which I represent and our team represents. Um, and knowing the undertaking that that's now going to put on Mark and Gasso and his team, where Gasso doesn't even have that ability to have that team up. He referenced many times that he is in the process of doing that, which explains those automated responses that our collective was receiving. Um, it just seems like the progression of time, Alex, is just going to continue to keep going on. And I mean, I don't know who's going to really be left standing in 2 weeks. And that's what really is troubling to me, knowing what I know about the collective to which we represent. And obviously, having your collaboration and being able to even speak to this level is a privilege. But I mean, what types of things can claimants do next? I mean, we saw yesterday a mass email go out about verification, and this morning people woke up conveniently before the hearing, and all of their documents had been removed. It wasn't addressed. There were many issues that were not addressed today. Um,
So
are we just going to keep going round and round for 2 more months in these hearings that are like 3 hours a piece, which seem really long? Is that typical for hearings like this?
So I'm going to answer those questions after I go through one YouTube comment. So there's one user who says that I'm trying to discourage your group from taking action. Just so you guys know, I'm not actually part of the court system. Our Nevada judges isn't controlled by the government. The judges don't actually control our group. What we do is point cameras at these specific courtrooms and allow you guys to view them. So we don't really concern ourselves with what you're trying to do in sort of your own case and stuff like that. I'm just trying to answer your questions in the best way that I
Mm-hmm.
possibly can. I'm trying to give you guys truthful, factual answers. I'm not trying to control what you guys do or don't do. And then we have something here in the Facebook where um, they're talking about, okay, so this is more like a comment on the court hearing. So I'm going to go into your questions now. So you're talking first about automated responses. My understanding is that the only way to get facts in front of the court is through very specific channels. So it seems to me that the general way that this is done is through the attorneys, and I guess you guys have a special master in your case, but I'm not really sure how that works, and I don't think that they take information directly from non-parties. I think that the special master takes information only from the attorneys. So any communications that go to anyone but the attorneys probably have no hope of getting in front of the court, and then of course the attorneys can then
Mm-hmm.
respond and filter these things out, and if you're getting automated responses from the attorneys in the case or the attorney that's representing, I guess, your side, you could say, then I'm not sure that you guys can do much more, at least much more than the attorney is doing,
Right.
because I mean that's sort of supposed to be the advocate, not necessarily for your group in its entirety, but for the issue that your group is trying to bring to the court's attention. And I can see how that
Mm-hmm.
would be frustrating. Unfortunately, I can't really give you an answer as to how to
Yeah.
solve that problem because that's really up to Mr. Thurman. The
Right.
hearing.
He had directed us to do that, to also include the special master in those. That was our directive when we did this second round of emails. And then, like, towards later this week, we started seeing claimants and people in the collective say, well, hey, I'm getting this response. And I had just directed them to continue to then to just email Mark at that point.
Okay, so then the other thing you asked about was how long the hearings were. They're usually a lot shorter, unless it's an evidentiary
Mhm.
hearing or a trial. Those can go for hours, sometimes days. But all of the other types of hearings that are not evidentiary hearings and not trials are usually much, much shorter. So it does stand out to me as a contrast from all of the other stuff that we've recorded and broadcast before, that your hearings, your non-evidentiary hearings, are going on a lot longer than I've seen before. I'm not sure if I missed another part of that question. Go ahead and ask me a new one, or if I missed something, let me know.
So you mentioned that, like, in court time, like, there's a certain time frame, but obviously in PUA time, as we'll call it, like, a minute longer is an eternity. And kind of coming away from today, knowing kind of what happened in the court, not being aware that people's documentation is being wiped out and different things, that's again concerning.
Mm-hmm.
Um, and there's not really been a directive on what to do next, let alone the platform doesn't have the ability in some people's cases being reported that they cannot re-upload their information. So a lot of the things that are happening on the back end aren't being brought up in these hearings, which almost seem counterintuitive.
Okay, so a couple of things there. So on the technical issue, I definitely know that that is something that's been happening for a long time, not even just with the PUA issue. There were issues with the DMV's website not too long ago that cost the state several millions of dollars. And in fact, I think that came out in the news yesterday or the day before that in Indiana, they had to go by the honor system on the what do they call it, the bar exam, because one of the software vendors put together some software that didn't work. So I think that this is a general issue regarding the government's, I guess, I don't want to say inability. They seem to struggle to get the best vendors paid or assigned or hired, or whatever word you want to use, to put together these systems. And these obviously impact the public in different ways. In this particular way, it's really bad because it has to do with the ability of people to get money, which then they're going to use to pay for food, pay their rent, pay their electric and stuff like that. So I think you guys are feeling it a lot worse than everyone else. But I guess this can kind of go into your other question, which has to do with getting mixed signals, mixed instructions from the government agencies, or I guess part of that question is not getting the help that people need from those who are in control. So the best way that I can answer this, and I get this question sometimes from other groups, other cases that are going on, people who are struggling, is it seems to me like there are these two tracks that people can go through when it comes to interacting with the government or the court system or the legislature, or whatever you want to, police, whatever. One of the tracks is just the way that everything goes, and it's typically the way that people expect to get their problem solved. There is this system or track or procedure in place that is working properly, and everyone goes through that process, and nobody needs any technical understanding, any legal understanding, anything. They don't need to research the rules. They just pick up the phone or type into a computer and they get everything solved. And then there's this other road, which is where you try to force the government to do something it doesn't want to do. And that is an arduous path from what I have seen in all of the different cases that we are covered. For the most part, what I have seen in all of the other cases is that when that approach is being taken, force seems to be the only thing that actually results in anything. And what I mean by that is um, the play nice approach, or the try to work things out approach, appears to be the less successful approach. And again, this isn't specifically in regards to your case. I'm trying to answer this question in the sense of what I've seen with all of the other cases that we have broadcast. So there's also something, and I don't know if this kind of goes into your question, but I've also noticed in some cases they talk about sometimes let's work things out and let's see if they settle in the long run. And sometimes I have seen in the past where the case can go into, I guess, what I call a sort of Cold War approach, where both sides are not friends, they're working against each other, but at the same time they're telling the court that they are trying to work things out, and maybe one side is saying that but isn't really actually trying, and then the other side is hurting, and then one side has an advantage in the delays and the stalling, and the other side doesn't and is hurting, but neither side really wants to just go to war, and so you have this sort of Cold War and those appear to drag on unless it actually does end up settling. So that's one of the things that I definitely noticed with this case is it seems like you guys are kind of going in that direction where you have two sides that are kind of friends, kind of enemies, and it's like unless it actually does get resolved, all it's going to do is end up delaying, um, the ultimate resolution in the case.
Exactly.
Um,
And I didn't think that that's a huge misconception. I think because I know that our collective has a great expectation of our team to handle things and what is being done. And I just want to just I know we're answering questions, but again, I just want to be really clear and concise to those that are watching from our collective or not. There were many actions that our collective took. Again, we started out at 2,000 in May and are now 16,000. And there seemed to be quite a bit of noise that we had made. It's been little, but it's been enough, we thought. So just kind of knowing that we're just this collective of like 16,000 people, obviously tuning in by via your channel and other platforms when these hearings are, coming on and we're seeing what we're seeing, and then it's not aligning with the things that are actually happening via the site or the system. Um, I know that during the hearing, my phone was going nuts. And I know that our collective is relying upon our team to answer questions, and it's very difficult to do so because we were given a directive and a set of instructions, and we followed them, and we did our due diligence, as Mark keeps saying, in giving the exhibits or whatever it is, and we're, again, I think you're correct in that Cold War. And so now it's kind of like when we know that we have this issue on the system end, but then we come out of this hearing where some things, again, were not brought up. And then we have this massive system wipe that I don't know how aware the court was of that. I know I had emailed the clerk. I had spoke to Mark's office during the hearing and let them know what happened, because there was a mass email last night that many that are in the collective got to re-upload their documents. And then again, before the hearing, they were wiped clean for some people. So it's kind of like the blind leading the blind. We're not in the Cold War. We're in the Cold War with the blind leading the blind. So any advice, I guess, it's not really a question, but any advice, or not really advice because you can't give us that, but potential direction that maybe we go in? I mean,
So I definitely can't do that, but what I can do is kind of redirect you to what I can
yeah.
do. So what I can do is give information and help people understand what's going on, and hopefully you guys can take that information and do what you will with it. And this information is based on, of course, my experience of broadcasting these cases and stuff in the past. But I think what you kind of just did is you circled back around to what I mentioned was the three sort of approaches to solving problems like
Mm-hmm.
this, which is the media approach, the political approach, and then of course the legal approach.
Right.
And I can define those things for you, and I can sort of let you know why some might not be working, but I can't really tell you what to do or tell you how to solve these problems. I only hope that what
Yeah.
I can do is try to make people less confused. And you know what is really important, I guess, for me to say is sometimes at the end of the road there is no victory. And I'm not saying that to upset people or because I want that to happen. But what I am saying is that sometimes you just don't get to a victory. Sometimes at the
Mm-hmm.
end of the road is a loss. And that isn't necessarily going to be the case for all three of those solutions. For example, in the legal area, you might not have a winnable situation. Mr. Thierman might be, doing what he can within his parameters because that might be what he thinks is the best approach for the approach he's taken, which is, the legal approach. But there may be approach politically that actually works. For example, I heard that there were some complaints by the Nevada legislature, some kind of communication to the Department of Labor federally, trying to get them involved to do some kind of investigation. So that's an example of maybe you can't win legally, but maybe there's a
Mm-hmm.
solution politically. And then, of course, I've seen Mr. Thierman, reaching out to the media and communicating with the media. So maybe he's got all of these different engines that are working, and he's hoping that one of these
Mm-hmm.
succeeds. So maybe, for example, all of a sudden there's like 100,000 calls or a million calls, and all of a sudden the media goes and takes it more seriously because of that. And all of a sudden, maybe the media path is what leads you to victory. I can help you guys by trying to sort of explain what I have seen in the past with all the other cases we've covered and what I have noticed, and sort of hopefully you can take that information and figure out what to do with it. Again, I'm going to answer your questions to the best of my ability. I'm not going to try to sidestep any or to dodge any. But yeah, let's take a look here and see if there's any comments.
Any questions in
Yeah,
the
so I'm
feed?
going to scroll through these comments really quickly. A lot of people watch the hearing. They're very upset about it. Massive waste of taxpayer money. From Steven Zellers, that's actually a complaint that we see a lot of times, not just in this case. In a number of other cases, people have pointed out that it appears to be a waste of taxpayer money when the cases drag on like that. Part of what we're trying to do, Mr. Zellers, is let you guys see what's actually going on. In fact, I've gotten complaints in the past from people asking, why do you put up boring hearings? Why do you put up 2-minute hearings? Why do you put up so many of these other hearings? Just put up like the verdict and something. And I'm like, well, we're not here to just put up sensational stuff. We want to let people see how the court system operates. And when people see how the court system operates, sometimes they sort of, it registers with them, this is a problem, we don't like this. As a citizen or as a voter, I don't approve of this. And of course, it can get people discussing it outside the context of the case that they're there to watch. And let me go ahead and go down here. But no, Mr. Zellers makes a good point, and that's not a point that he's the only one to make. That's a point that I see in multiple different cases. Mr. Berzik is talking about how the government is, quote, straight up robbing us, unquote. And that comes down to the problems with the law that have to do with enforcement. Mr. Berzik, or I hope I'm pronouncing his name, I'll just call him Brad. What he's saying is true in a sense because the government passes statutes that are expected to be complied with. Those statutes say you guys are supposed to get money, and then yet it's not happening. And that goes to court enforcement issues. So sometimes there is a law, something is supposed to happen, but for whatever reason, whoever is trying to enforce the law or get the law to actually, do what it's supposed to do isn't doing that. And you end up in this type of situation here where an attorney is trying to get the judiciary involved, and he's trying to get the judiciary to sort of arm twist the government into doing what they're supposed to do. Let's see what else we've got here. Let's still scrolling, looking for another question.
I know that there's a lot of angry people, and we understand that you're angry. We're all in this together. As we say in our group, we are PUA strong. I know that you guys are all disappointed, and I know that there will possibly be some misguided anger, but we want everybody to know that we're going to continue to keep this group open and available to hold space so we can continue to keep taking our next steps. At this point.
We got a comment from KB. Yeah, that's true. I mean, and just so I hope that your viewers know this isn't our full-time job. There's a handful of us that volunteer and do this. So we don't have to actually, do this. And in fact, our Nevada judges actually sometimes ends up butting heads with the judiciary and the attorneys. Comment from KB saying we're trying to help people understand the court process. Our Nevada judges is not part of the government. That's true. For me to get access to court hearings, I actually have to follow all of the other processes that the media does. And it does sometimes upsets the judiciary, sometimes it upsets attorney. It's not necessarily a situation where we're buddy-buddy and friends with everyone that's involved in the government. No. We're trying to get you guys eyeballs.
I think that's a big misconception though, right? Like, I mean, I'm sure you probably face that a lot, that people like people associate myself and my team as people that work for the state of Nevada. And we clearly and adamantly are not spy kids. We do not work for the state of Nevada, D.E.T.R, anybody, the government. We are just claimants. So I'm sure you experience that quite a bit yourself with your page, obviously representing hearings, with people thinking that you are playing golf with these judges and your best buddies and you guys cook out every weekend with your wives.
No,
so yeah,
it's the exact opposite. In fact, I've had probably 12 or 13 objections to media requests filed since our inception, and I think if we were buddy-buddy, we wouldn't have a single one. So over a dozen objections to media coverage. I think it's pretty clear that they're not buddy-buddy with us. So I'm going to go ahead.
So it would be safe to say then, I'm sorry, just to finish on that, because I think that is a huge point that we need to address. I know it's not something that you're concerned about addressing, but I think since we're here, it's worth addressing. So, again, you're not a part of the judiciary system, but again, we're not part of D.E.T.R. You mentioned the platform of media being one of the three things. This is Alex obviously giving us, our Nevada judges, giving us the opportunity to do that. Obviously, because our efforts in emailing and doing things weren't potentially working or they weren't enough. I wanted to come on here today because I was given an opportunity to speak again on behalf of the collective and use our voices. So that's exactly what we're doing here. I have no issue in being totally transparent and honest in that. I have nothing to lose. I believe in the people of PUA as much as I believe in the work that our Nevada judges does. And we are so grateful for obviously the extension of your generosity and time in doing these things for us. So I just want to tell you, thank you. for doing all the things that you have done for us to make sure that our voices are heard. It's been greatly appreciated.
Okay, we got two really good questions here. One from Mr. Zellers. This
Great.
is an excellent question. Why would the judge preclude his original mandate with expecting a heroic response and have an initial rush to get the decision by July 21st just to be satisfied with very little results? Mr. Zellers, I'm going to answer this question. I'm not going to try and make it sound bad. I am just going to give you an observation, and I will let you and all the other viewers do what they will with it. Okay, again, the judges have so many cases. I think that what's happening is they can't remember what they said at the previous hearing. And I know it sounds bad. I'm going to tell you guys the truth because that's my observation from having done this for this amount of time. They have a lot of cases. They have a lot of hearings. They're doing stuff all the time. I'm not giving an excuse. I'm not saying this is okay. I'm not saying this is how it should work. I'm just telling you what I have observed. It seems to me like they can't remember what they said or what happened at the previous hearing as clearly as people imagine that they would. They probably do remember sort of overarching general ideas, but they don't remember necessarily the intricate details of what's going on. I've also heard people complain that the judge is going to court knowing what they're going to do already. That's true. That's true, but again, that's not necessarily because they don't care. The reason why is because they read all the briefs prior, and usually they know what they're going to do based on the briefs that they have reviewed. I guess sometimes it might seem like they change their mind based on the oral testimony and the oral arguments provided at a hearing, but it's not always the case. And that kind of ties into what I mentioned with regards to the memory. It seems like their way of sort of recalling what occurred at a prior hearing is more heavily based on rereading the briefs that have been filed than it is so much on actually remembering what they've stated prior. The other thing that I want to mention is, so the Supreme Court of Nevada has stated this before, oral pronouncements from the bench are not effective for any purpose, at least when it comes to reviewing the judge's decisions, and I'm pretty sure with enforceability as well. So it's not unusual for a judge to say something and then not enter that into his order. And when that happens, the thing that he said but didn't enter into his order, it is presumed, at least according to the Supreme Court, that the judge changed his mind. Ordinary people who are not involved in the legal system do not like this. And again, I'm not saying that it's bad or that you guys should like it. I'm just trying to help you understand that they don't think in terms that are the same as maybe the average person does to a lawyer or to a judge. Saying something, making an oral pronouncement from the bench, and then not putting that into the order to them is okay. They just figure that's not really something that I want enforceable, or I changed my mind, or that does happen. Again, guys, I'm not saying this is okay. I'm not saying that you should that I support it, or I'm just saying that that's just the way it works, and hopefully giving you that information will help you understand why it's happening. The second question that was really good is from D.D. Palmer. He says, is there a reason why the state would not want to pay the claimants? Is there a political reason for this? I can't give you a specific answer, but I do. I know that you're like surprised. I got a reaction from you on that one.
My God!
I can't answer.
Welcome to the Pua Catalyst.
Well, the thing about that is, it's actually a good question, and there's actually an answer to that question. Even though
Great question. I love that question.
Even though I can't give him a specific answer based on this specific case, I can give him a general answer and let you guys do what you will with that information. Sometimes, and again, I haven't read any of these laws, so I don't know what applicable law is going on in your case. Sometimes the federal government will include certain provisions of a statute into a gigantic bill. And so sometimes the money, I guess in this sense it's money, sometimes the money that you feel is supposed to go to you is actually only one provision in a series of statutes. And so that money might be going to other places because there might be other statutes that allow it to happen. So for example, there may be a statute that says, you know, there is the CARES Act, and there's the PUA benefits, and you're supposed to get, let's say, $1 billion. But there's all sorts of things that it can go into in that statute. And so that money might actually be getting dispersed, but it might be going to other things that the federal government has said the funding can go to. Again, I haven't done any of this research, but I've seen this a lot in the past where the legislature doesn't really create a bill or a series of statutes that just pinpoint exactly where every dollar is supposed to go, but usually they'll have like a certain amount of money, like a big chunk of money, and it can go to a variety of different places. And then of course, once the executive branch takes over, they end up putting the money where they want it to go, as long as it's consistent with what the law allows. So I suspect that there is an answer to that question, and that it may be going to other locations, but it might not
Mm,
necessarily be illegal. And again, I
yeah.
can't give a good answer because I'm not an attorney and I haven't researched that law. All I can say is based on my observations in other cases,
Hmm.
this is actually pretty standard for the statutes that
It
actually,
does happen.
yeah. I'm going to go ahead. There's a guy here making a comment on geologic solutions and Alorica Light Forge. I assume that these
Ooh, ooh,
are,
ooh,
go ahead and
ooh,
let me know
ooh,
what these
me,
are.
me, me, me.
Go ahead and let me know what these are, and I'll try to answer your question. Keep in mind, I do not know what Geologic Solutions or Alorica Lightforge is. So go ahead and tell me what that is and ask me a better question.
I do, I do. I got the answer. I got
Okay,
the
go ahead.
answer. Uh, Geographic Solutions for 1,000, Alex. Okay, guys. So, Geographic Solutions is the vendor that is currently running the system. So, the portal that we're using, they're the software company that was picked by the state of Nevada. I've had actually contact with the software owner myself. That was something that I didn't share outwardly, but now that I have this opportunity, when in Rome, we will. So I have contacted and reached out to them, as many of our claimants also have as well, and have been met with responses anywhere from D.E.T.R needs to let us know that there's a problem, or you need to go ask D.E.T.R. So again, the merry-go-round goes around again. The other one, which I can never pronounce it, and I know that I'm really bad at pronouncing names, the call center is the whatever the hell you call it. It's the call center that nobody answers the phone at, and hangs up on you after 5 minutes. So those are the two vendors that they chose. Those two, they don't have a relationship with one another. So they're all actually, I don't know if you would consider them third-party vendors or what, but they're not actually through the state of Nevada. They've all been outsourced. Many of the people um, are actually not in the state of Nevada, according to what was originally reported by D.E.T.R. When we have found this out, obviously there's a screaming bird lady in Florida who answers, a lady in Alabama who answers, and people all over the country that answer that are not in Nevada. Um, uh, and the runaround that we keep getting with both of those vendors is that D.E.T.R has to let them know, or they have to be the ones to fix it. But then we were told that there's only a handful of those people that are actually able to do it. Um, so again, like we kind of saw today in this hearing of it kind of going round and round, like you speak to at those briefings, we are in the same cycle now with the vendors, because the collective had originally started before we got to the legal realm of contacting those people, and we got nowhere.
Okay, so there are a few things that I can comment on. So it sounds like,
Mm-hmm.
in the sense of the government hiring bad third party, incompetent third party vendors or bad third party vendors, I guess the only thing that the public can really do about that is get involved in local elections, because I believe those are not hired by the federal government. I think those are hired by the state of Nevada. I'm not sure. With regards to only certain people can make decisions, I think there are statutes, and that's why that's going on, because the way unemployment
Right.
works is defined by statute, and the people who can adjudicate those claims are also probably
Yes.
within the definitions of those statutes. So that might be a problem that they're
Right.
having where they have hired a bunch of assistants from a third party vendor,
Yeah.
but maybe
So
not all of
yeah.
those people are able to adjudicate claims. And then I guess when it comes to software engineering, we talked about that a little bit earlier. So if the Geographic Solutions group is the one handling the software, then that kind of ties into what I talked about earlier. We're getting tons of questions and comments. Guys, I'm going to check the Facebook in a second, but I'll go through the YouTube comments really quickly, and then I'll switch over to the Facebook ones. Um,
I'm getting
Mr.
messages about how to pronounce
Burzes.
the call center. I am sorry, guys. I can't pronounce it.
And the
Trust me,
thing is,
everybody's tried to get me
one of the
to.
things that I think a lot of people do live is they just sort of speak to the camera and ignore the comments. But what I'm trying to do here with Amber is to actually check the comments and see what it is people are asking. That's why I'm speaking so fast, and that's why I'm moving so fast, because the comments are filling up so quickly. That's also why you guys keep seeing me look at the side, just letting you guys know what's going on. So let's see. D.D. Palmer says, but what is the political reason? I don't want to hear conspiracy theory. I hate to break it to Mr. Palmer, but this isn't a conspiracy theory at all. This is actually just the standard way the law works. And I think that's one
We're
of
in an
the,
election year.
well, I think a lot of people jump to conspiracy and they
Yeah.
don't realize that most of the time it is just how something works, and
And statutes and the
it
law and
seems
everything.
like it's just that particular group getting picked on, or they're alarmed, or they feel like it's just them, and it's really not. It's just the standard. I've heard a lot of complaints. I get a lot of messages from your group about the Department of Employment Training and Rehabilitation. And I hate to break it to them, but the things that they're complaining about are similar to the complaints that I've seen in the past. The only difference that I see is there's just a lot more now because there's so many
Hmm.
people that are trying to get these other benefits and because the system is overwhelmed. But there's
Hmm.
nothing new about any of the complaints. There's just more of them.
Of us,
And I
yeah.
think it goes to hold on a second. This is just my background. And I think it goes to people's frustration because they don't understand why that's happening. And it's just, I hate to say it, but it's just
It's
the,
how they've been from the
it's
beginning of time.
right.
It's just now we have a group of 16,000. So where I can clarify for you
Mm-hmm.
is that what I guess Alex is trying to say is that before with Dieter, and he's familiar with this because he's had experience in this realm,
Mm-hmm.
with Dieter, is that it's just standard operating procedure. And normally it's like 5 or 6 people that need to appeal, like maybe a UI claim. But now here we are, and we've got 16,000 people. So we've got a swarm of people. We don't just have 5 or 6 that, like, whatever, go under the radar. They're not on the news every day. We're not, in a Facebook group that has grown to be this large. So
Yeah.
I think that's pretty much what you're trying to confirm, is that basically, this has been something that has gone on probably for decades,
Yeah.
under the radar. And now all of a sudden we are in a situation to where it's been exacerbated and it's got a microscope on it.
Yeah.
And that's not necessarily a bad thing or a good thing. I think it's probably maybe a middle of the road thing. Like maybe it can perhaps lead people to be more engaged, obviously, like Alex said, in their voting and election participation, using their voices and demanding change. I think that's something that's we've taken away from our experiences so far here in this group. Unfortunately, though, our response, Alex, from a lot of our state legislators and representatives has been lackluster, to say the least.
Okay.
There's been no response. So is there a way for Nevadans to take this more to a federal level, like through the DOJ or through other people? Like, are we able or in a capacity to potentially go beyond a state level and make
Well,
noise?
of course, I mean, the legislature in Nevada is asking for the DOJ's assistance. Anyone can ask the federal government or any agency for assistance. The question is, are they going to listen
Mm-hmm.
to you? And so
Mm-hmm.
sometimes when it comes from authority, it helps, and other times when it comes from a whole lot of people, it helps. But it's not
Mm-hmm.
always something that there's no exact formula to that problem. It's just whether or not the particular agency actually wants to get involved. There's tons of good questions and comments here. So we got
Okay.
one here from Jacqueline Flores. Why don't we have a live aftermath with the lawyers instead? This is an excellent question, and apparently this is something that Amber has tried to do. And I go ahead and take that over because I think that it's
Okay.
important for them to know.
So
Go ahead.
yeah, it is very important for the collective to know that I have been in contact with Mark and Mark's office since the very beginning, and I have been in contact with many legislators. I've also been in contact with a lot of people that the collective perhaps may not even know about, because I'm not trying to go running around and bragging about it, really. And it just, there's no sense in it, because sometimes we don't know if it's going to be a dead end or if it's going to be an end where we reach some type of next part of the road or whatever. So, um, all I know is that, like, I want the collective and people that are not watching to know that every single time there has been an issue in the last couple of weeks since this has happened, I immediately notify the group and the team. Like, I have had a couple of conversations where Mark is on the call, but most of my interactions are with the paralegals and the people that are working on getting the emails collected. I know that I got a lot of response of, like, where's my email and what it happened. And I think people just have a misconception, I think, again, like you say, Alex, about how the legal process works. It wasn't that they did not get your email and they did not respond to. There's certain statutes that don't allow them to respond.
Hmm.
There are certain laws and rules that don't allow them to engage, as we saw with some of Gasso's earlier replies to people. But I just want to, since we're on here right now, I just want to clarify this very clearly, that sometimes there won't be a response. Sometimes it's just a gathering of data. And luckily, our group is at an advantage of having 16,000 people that can see a post in one place and act.
Hmm.
Um, so I have had many dialogues. I literally was watching the hearing today, and I was watching, for lack of a better word, the shit show ensue. And I immediately called the office and I said, wait a minute, like, this is not, like, and I brought up some new issues, and I said, they were hoping that they were going to be able to get that information into them about the disappearing documents on the portal and the mass email last night into the recess, and let them know what was going on to maybe steer the course a little bit different. But we want the collective to know that our interactions with people, are at the level of engagement. We can try and do all the things that we want to do, like Alex says, but that doesn't mean that that's going to produce an outcome.
But they can at least get the information that they need so that they're not so
Yes.
confused, and so that they're not
Yes.
so, because right now I'm sure they're losing confidence in everyone that's involved. And so this is a small thing that I can do to answer questions. So we got a great question from Mike Hammertime. But before I go into Mike Hammertime's, I'm going to switch over to Facebook because I've been neglecting those comments. So let's take a look. I'm going to scroll from the top down. Let's see.
Woosah.
Scrolling down. So the Facebook ones are mostly comments, no question yet.
Yeah, but yes, they did get everybody's emails. There were some that maybe perhaps were missed, but they did set. Some people got replies, some people did not. It just depended on what the subgroups. But I want the collective to know that we are so highly appreciative of you guys participating, because I don't think, even though today's outcome wasn't like the best one, I don't think we would have maybe potentially gotten this far had we not brought to their attention some of these subgroups and bottlenecks. I feel like we accomplished something today, and that's something to celebrate, because we are this group of people of 16,000 that has, in the last week and a half, sent thousands of emails. And I know Alex speaks to it being in a bigger volume. Let's start emailing again. Let's have an email party. I mean, I'm down for it.
Okay, so
I think that it's productive at this point if we continue to keep doing that. I don't know what will happen with Gasso's email. I know I have a ton of questions about that. He said today on the hearing that he's planning on implementing a new system so he can take the volume of emails that were coming in. But yes, our interactions are there. They're existing.
So we got only one thing that I can talk about with the Facebook. Mostly it's comments and frustration, but there is one, which is okay. But there is one here from Rose Trina, who says, I am so sick and tired of companies outsourcing. I do have an opinion on this. When it comes to software engineering, I have to take off my Nevada judge's hat and put on my software engineer hat, because this is what I do full time. So what I have seen in all the companies that I've worked for, because I've written code and I actually wrote the entire code base for Nevada judges, including the database, the server, the API, everything. What I have seen in my experience of being a software engineer is that vendors and outsourcers have different objectives from in-house employees. The in-house engineers are going to try to complete the project, of course, but they're also going to think to the future. They're going to complete the project in a way that can be pivoted or adapted or scaled or advanced or changed. They're gonna keep these things in mind when they develop the product, because they're thinking, I work here and this is going to come back later when we have to change something, because maybe we have more traffic, maybe we'll need a load balancer, maybe there's new laws and I have to change the questions on the form. So they write the code thinking to the future. Third-party vendors don't do that, because that's not how it works. So they get a contract, they have a clear beginning, a clear end, and it's basically going to come to profit and loss. You know, the amount of money that they pour into developing the software is going to be compared to the amount of money they're being paid, and if they can, the larger the gap is, the more profit that company's going to generate. So they're not necessarily thinking, I need to put this thing together in a way that we can come back to it 4 years later, because they don't know if they're going to get another contract 4 years later. Somebody else might get a contract to alter that code. So third-party vendors, there is this sort of disadvantage that I have seen in my experience working with them, because they are just thinking, how do we solve this problem as quickly as possible, close it out, get paid, and move on. So there's different incentives and different motives there. And that's probably the best way that I can answer, or at least make a comment on Rose Trina's question. I'm going to switch back to YouTube.
I think to piggyback off Rose's question or comment would be that, I mean, my opinion on that, and obviously, hearing what your knowledge is that, when a state decides to basically third-party vendor something out, why they go through that systematic process you just spoke to, I think it's also kind of a disingenuous way of saying, like, you know what, like, we don't care about maybe perhaps investing into doing this perhaps the correct or right way, because we know that, in some of my, dialogue that has been with Geographic Solutions, it was some of those things that you speak to, of it not being perhaps maybe loaded or coded correctly from the start. Because we see this group of first-time filers. I want to acknowledge our first-time filers right now. Like, we know what the problem is. The problem is that trying to get D.E.T.R to recognize that what the problem is. I mean, I hate to be the bearer of bad news, but that's what I'm good at. That's just what's happening. And I'm just a little itty bitty claimant that's an admin of a group, and I identified that early on, screaming that from the rooftops, and then. We saw a lot of filers. I think it was probably about mid-June when we started seeing new filers being paid out sooner, which seemed to align with Geo's objective of updating or ironing out the kinks, needless to say. But the
So,
problem is that we never went back to this initial first-time filers, and these are these people that are stuck with, again, no issues and problems, and have no indication as to why, by via calling the call center or calling D.E.T.R, why they're stuck. Just hurry up and wait, hurry up and wait. Um,
so I'll jump back to
yeah.
Mike Hammertime's.
Mm-hmm.
And let's see. He
And
says, "Is there a precedent or timeline per the law for successful completion of a court order?" Sometimes there is, but my understanding is that when the court orders something and somebody doesn't do it, then what is the response is in order to show cause, to hold them in contempt of court. And
mm-hmm.
with that general statement, I haven't seen anything that really creates some kind of special, like specific date and time that they
Mm-hmm.
have to respond by. It's often one of those murky, fuzzy things that comes back to court on an order to show cause to have somebody held in contempt. And then, of course, the first thing that has to be shown is there was a violation of court order. And then the second thing is, was it on purpose? And so with the first one of the defenses is often, well, we are trying to comply, but we're not done yet. And then with the second one, the defense is, okay, we're in non-compliance, but it's not our fault. We didn't mean to. I don't think that Mike Hammertime wanted to get that answer, but this is actually a question that I've seen a bunch of times, including, or especially in some of the child custody cases that we cover, child custody guardianship. We don't cover direct child custody cases, but some of the ones that are connected to the criminal justice system. We have two specifically. And this question comes up because people wonder why there isn't more specific parameters in place, why it's so fuzzy or murky. The answer to that is because that's how they've written the law. The legislature fashioned the law that way. They didn't set a deadline or a time limit like that, and because they didn't, it's not there. And then the other part of that answer is publications from the Supreme Court of Nevada don't really clarify on that. They don't actually set what they call bright line for compliance. I'm going to just do about 5 or 10 more minutes of these because I'm going to have to wrap up. Let's go,
Yeah,
Brad.
I can do like five. I can do 5 more minutes, guys. I mean, this is
Yeah,
actually a privilege to be able to even do this, but I felt very adamant about coming on here and kind of clarifying some things objectively for the collective and obviously people that are watching now publicly.
right. So
You
Brad,
know,
sorry.
so yeah, go ahead and we'll finish. Sorry, yeah,
I'm
we
not
got
trying
like
to.
5 more minutes.
I'm not trying to cut you off.
Yeah,
I feel so bad because I want to answer all their
I
questions.
know, me
Yeah.
too. I've been up
So
since 4 in the morning.
right. So Brad says you pronounced my last name incorrectly. It's Polish, and he apologizes for his irate comment earlier. First, I apologize for getting your name wrong, and I accept your apology. It's fine. I understand all of you are frustrated. I'm not taking anything personal. If you're angry with our Nevada judges or you want to attack ONJ, that's fine with me. I get that you guys are very frustrated. Mike Hammertime says in. Oh wait, so that's okay. That's not actually what we can ask. It's just a statement. I'm still
Yeah, it's a lot of
scrolling through.
statements. I'm seeing it too. It's just a lot of statements. I know everybody's upset, and I know that.
Well, people being upset often does lead to change. It's just
Yeah.
it's not usually instantaneous. That's one of the things.
Okay.
And I think a lot of times people think that the system is a certain way and they don't know that it's not the way that they thought. And so when those
Mm-hmm.
people go to the polls to vote, you're not really going to get their support because they're just going to assume that the system operates in a way that's functional. And so sometimes just letting people observe the system in its operation, letting people watch the wheels of justice turn or watch how the legislature operates, makes them realize, hold on a second, everything that I thought isn't true. These things aren't actually working well. And then, of course, they're able to actually join your ranks and assist you when it comes to political or media solutions. So I don't think that people realize one of the biggest things that gets in the way of solving a lot of these problems is that other people just don't even know it's a problem. And so that's one of the purposes behind our Nevada judges is to actually let people see how the system operates and form their own opinions. And oftentimes you get remarks like the remarks that we're seeing here in the comments. And so it's heartening to me because I can see that people are actually connecting what is going on from what they thought was going on, and they're able to sort of change their opinion based on what they're seeing. And those people will, of course, take that to them when they talk about things with other people who maybe are not going through the PUA struggle, and maybe their friends and family will realize, okay, so this guy says things aren't going really well, maybe I'm wrong, maybe what I think about how the justice system operates or how the legislature operates isn't good. Anyway, I'm going to go ahead and wrap these up. We're almost out of time. Still scrolling. Oh, and if I got anyone's name wrong or gender wrong, just keep in mind the reason why is because I'm going as quickly as possible to answer as many questions as possible. If I go slowly and I'm more accurate when it comes to these things, then less people are going to get their questions answered. And so I've decided in this particular case to answer as many questions as possible, which is why I'm going so quickly. And it's also, again, guys, it's why I'm looking to the side constantly because I'm reading through your comments. Why appoint a special master to make suggestions to the process, then ignore those recommendations? Steve Zellers, again, with another great comment. This is a comment that I see all the time in all sorts of cases, usually brought up in the context of parenting coordinators, custody evaluators, expert witnesses, etc., etc. I don't have the best answer to give you. What I can say is that the court is not required to take the recommendations of any of these experts or witnesses or masters, and so sometimes they don't, and that's definitely not what he's going to want to hear. In fact, that's going to probably concern a lot of people because I don't know if anyone's been watching sort of towards the end of that hearing, but apparently the funding or the money that is going to be paid for that is going to be borne by the parties. So it's going to be borne by the government on one side and by Mr. Thierman on the other. So yes, sometimes these people are appointed and sometimes their recommendations are ignored, and the court has, it's the court's prerogative to do that. There may be reasons as to why they do it. Typically, the court will want to take their findings of fact, but apply their own conclusions of law to that master's findings. But I can't tell you specifically why in this case this is happening. All I can do is confirm for Mr. Zellers that it does happen and that it's not just in this case. Raquel Karaginas says, to be honest, many have given up because their lives have already been messed up. Definitely understand that that's what's happening. I mean, it's pretty obvious why that would happen, because people wouldn't be able to fund their lifestyle. They wouldn't be able to pay their rent, pay their bills, or buy food. Why did the judge not allow for discovery today? Excellent question by Brad. I love when I get technical questions because I like to teach people about the judiciary. For people who don't know, go ahead.
Mark asked that too. I don't think he asked like maybe in reference today, but I think he did ask that at the end. So that is a great question.
So first off, people need to know what discovery is. Most of the average people don't know what that is. Oh, we're getting a feedback loop. There we go. Okay, so discovery is a process that allows the attorneys to force each other to turn over information, and that could be through the form of request for production of documents and things. It could be answering questions, which is interrogatories and requests for admissions. It could be compelling the appearance of witnesses, which is by subpoena. It could be forcing third parties to respond and turn over information, which is by subpoena ducis tecum. Opening discovery gives the attorneys an arsenal of tools that allows them to, on their own, without the special master and without the court, force information to be turned over. The question was, why isn't it happening? Well, discovery is, I don't want to answer for the judge. I can only speculate, and I can only give reasons as to why he might not have wanted to do it. Typically, discovery is seen as an expensive process, and typically one of the reasons to oppose discovery is because the court or one of the parties does not want to go through the expensive process that is discovery. When the attorneys start to use all of these different legal instruments and tools, money has to be paid in some way, shape, or form for that to occur. And then, of course, oftentimes people will dig their heels in, and you'll see people not turning over information, which leads to motions to compel. So the discovery process is an arduous process. It is a rigorous process, and it will lead to information being turned over. And it's also a prelude to an evidentiary hearing or a trial, which will allow the court to enter orders against the other party over their objection. So these are, Mr. Thierman asking about this might be his way at hinting we need to move this thing towards an adversarial determination, a determination that both sides don't agree to, a determination that is imposed on one side. And that might be what he was hinting at. And the reason it didn't happen might be because of financial issues, money issues, what the court wanting to avoid expanding on the litigation. The court might want to keep everything in sort of the settlement, let's work things out stage. I'm going to hurry through these so that we can wrap up and move on. Are the court's timelines for writs of mandamus strict or suggestive? Again, is Mr. Zellers an attorney? He's asking excellent questions. These are wonderful questions. I want to see more of these. Mr. Zellers, no, there aren't any. Unless the law says so, there aren't any. It's an excellent question. Why aren't there any? Because the legislature didn't fashion any. Could be the federal legislature, could be the state legislature. Unless the legislature says so, there isn't a timeline. There has to be a specific something in the language of the statute that makes it strict. Otherwise, it's not strict, and it becomes, as he says, the word he's using is suggestive.
But yes, that would stricter laws actually do lead to more predictable outcomes, because then when those laws aren't complied with, people can seek relief from the appellate courts. One of the things that we do at our Nevada judges is we track how often judges make mistakes, and one of the most common reasons that decisions are overturned on appeal is because the strict language of a statute wasn't complied with. And so when strict language is out there, it does impact these cases. It does control the timelines. It does hurry things along, and it does make things more predictable, because people know that, this isn't so murky. The legislature said this needs to be done right now or by this date and time, and it's not been done. And if the judge isn't going to do it, then the appellate court will force him to do it. Excellent question. Let's see here. Hurrying through these. Any news on what they're doing with appeals? Maybe we'll do this again
I'll be there in
sometime.
1 minute.
You know what we'll
Yeah,
probably
I
have to
gotta wrap
do?
this.
Let's wrap it up, and
Yeah.
let's do this again another time.
I've got
But
little people around.
It looks like a lot of your community is starting to calm down, and they're asking excellent questions. Towards the bottom, I see questions that are on point, technical questions that deserve answers. But we're out of time, guys. In the future,
I'm sure we can have an opportunity and space to do this again, guys. But we just wanted to come on here post hearing and kind of clarify some of the things that are going on, and use our time with Alex as an opportunity to share more with people that are beyond our community as well. So
you're very welcome. I'll see you guys around.
I appreciate. All right, thank you.
Best of luck. Goodbye. We're still live. Hold on a second. Ending streams, and streams are ended. 1, 2. They are both down. Excellent. See